This is Bloomberg Law with June Grasso from Bloomberg Radio.
The classified documents case against former President Donald Trump came to a stunning and abrupt conclusion this week as federal judge Eileen Cannon dismissed the case outright. Cannon's dismissal had nothing to do with the evidence, but was based on a procedural point, with the Trump appointee finding, against the weight of prior decisions, that the appointment of special counsel Jack Smith was unconstitutional. The case charging Trump with illegally hoarding classified documents was widely considered to be the strongest and most straightforward case against him, involving conduct after Trump left the White House, and with the breadth of evidence, including surveillance footage from his own security cameras at Mar-a-Lago and the testimony of close aides and former lawyers. Plus, remember Trump's bizarre explanation for the declassification of the documents.
If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it, because you're sending it to Mar-a-Lago or to wherever you're sending it. And there doesn't have to be a process. There can be a process, but there doesn't have to be. You're the president. You make that decision. So when you send it, it's declassified. I declassified everything.
The special counsel has already filed a notice of appeal of Cannon's decision with the 11th Circuit. Joining me is former federal prosecutor Robert Mintz, a partner at Carter & English. Bob, even though Judge Cannon has issued a lot of mystifying and unorthodox decisions, this decision dismissing the entire classified documents case still caught most legal experts by surprise.
This is really a stunning decision by the federal judge in Florida to throw out entirely the classified documents case against former President Trump. It's something that I would suspect that not even the Trump legal team was expecting based upon the hearing that they had on this issue before the judge. But what the judge did here is basically find that the appointment of the special counsel, Jack Smith, violated the Constitution. It does not address the merits of the case. It doesn't address the evidence. It doesn't address a defense that was raised by the Trump legal team. It's all about the appointment of the special counsel. And the judge found because that was done improperly, the only remedy is to dismiss the case.
Why did she say it was done improperly? How did she find that?
Well, the judge wrote a 93-page, very detailed opinion which focused entirely on the Constitution's appointments clause and said that the appointment of the special counsel was done inappropriately because it was a violation of that clause. In other words, the judge found that the appointment had to be approved by the Senate, had to be confirmed by the Senate, given the level of independence that Jack Smith was given by Attorney General Merrick Garland. The judge also found that the appointment violated another clause in the Constitution having to do with the expenditure of money. That was not ultimately the basis for the dismissal of the indictment, but she found that the appropriations clause also was violated here because money was being spent improperly, again, because it was done without congressional oversight.
Cannon wrote that the issue of a special counsel was a novel one. But it's not a novel one. This has been decided by other courts before.
That's exactly right. This issue of an appointment of a special counsel is something that has been done by different administrations over the years, dating back many years. Both Republicans and Democrats have used the special counsel as a way to investigate politically sensitive cases. And it has been challenged before, and every time in every court, this type of appointment has been upheld, not only by district courts, but also by the Court of Appeals.
It seems like she took a recent concurrence by Justice Clarence Thomas to heart. In the presidential immunity case, Thomas raised concerns about the constitutionality of the appointment of the special counsel, which wasn't part of the immunity case. And Cannon cited that opinion, which no other justice had joined in, 3 times in her opinion.
Yeah, that was unusual because you did have a situation in connection with the presidential immunities case where Justice Thomas made a comment about the appointment of the special counsel. It really was outside the scope of the opinion, and as you say, none of the other justices commented on it, but it does seem to perhaps have affected the judge's decision here because if you look at the way she reacted to the arguments during the hearing, she seemed to suggest that she would go along with the other courts in the way that special counsels had been appointed over the years, because there was a longstanding precedent over many years and many different administrations to appoint special counsels in this way. And yet we now have this decision which really has stunned the legal community because it has thrown out a precedent that has been in existence for at least 20 or 25 years with regard to the appointment of special counsel.
Explain how Judge Cannon has not only slow-walked this case, but her decisions have subjected her to a lot of criticism for being outside the norm.
Well, people who have been watching this case from the beginning have been a little bit mystified by the way Judge Cannon has handled this case, in that she has given a lot of time and devoted a lot of energy to arguments that most judges, based upon past precedent, would have dismissed summarily. In other words, it's not surprising at all for a defense team to make all kinds of arguments, including some that are very far-fetched. That's something defense lawyers will try to do because you never know what might actually pique a judge's interest. But most of the time, judges very quickly dismiss arguments that are out of the mainstream to try to keep this case moving, to try to keep the case focused. In this case, it seemed that Judge Cannon was giving an exceeding amount of deference to arguments that most judges would have dismissed out of hand, and this has slowed down the trial considerably. And now we have sort of the culmination of all of that, an argument that seemed like a far-fetched argument, an argument that was really kind of a Hail Mary argument in the eyes of most people, given the lengthy legal precedent supporting the appointment of the special counsel, and yet she has now found that as a basis to dismiss the case altogether.
I just want to point out that Cannon's decision has no effect on the D.C. case, which is in a different circuit. Now, the special counsel certainly has strong legal arguments for his appeal. It's not clear if he's going to ask to have Cannon removed from the case. There is precedent for that in the 11th Circuit.
Well, that's the question now as to whether or not this is an appropriate time to do that. She already does have a bit of a shaky history with the 11th Circuit. If you remember, during the beginning of this case, when the search warrant was executed, she asked that an independent monitor come in to review the documents that were seized by the government, something that was highly unusual, and really there was no basis in law to do it. She more or less found that because the subject of the search was a former president, that there was a certain level of due process that had to be accorded that was different than anybody else. That was immediately overturned by the 11th Circuit, and she was really rebuked by the court for going way outside of the mainstream and trying to create a basically two-tiered system where somebody, because they're a former president, gets a certain level of deference and a certain level of due process that every other citizen in this country would not get. This is now going back up to that same 11th Circuit Court of Appeals, and it'll be interesting to see what they do with this decision and whether or not they overturn her ruling.
It has long seemed like this case wouldn't be tried before the election. This decision just about ensures that.
Either way, this seems to be a tremendous win for the Trump defense team because in the first instance, the case has been completely thrown out. And even if the Court of Appeals does reverse it, it's going to slow the case down to make it nearly impossible to have this case tried before the election. And this is really troubling for the government because let's remember, this was viewed by many people as the strongest case brought by the Department of Justice and, in fact, even by state prosecutors against former President Trump, because it did not involve a novel legal theory as some of the other cases did, and because it was focused almost exclusively on actions after he left office, which removed it from some of the immunity issues that ultimately is going to be a problem for Special Counsel Jack Smith in connection with the January 6th case. So while this case was perhaps not the most exciting, it involved improperly removing classified documents according to the government, and then the government alleged that former President Trump obstructed the government in terms of their ability to retrieve those documents. While it's not the most exciting case out there, it was really on the most solid legal footing, and prosecutors, I think, thought that this might be the best chance they had out there to gain a conviction in one of the federal cases.
This is another in a string of recent legal wins for Trump. That controversial Supreme Court decision this month on presidential immunity has put the D.C. election interference case on hold and even delayed the sentencing in the New York hush money case. The Georgia racketeering case is also on hold pending an appeal. What does it say about the legal system that only one case out of 4 went to trial because of the never-ending motions filed by Trump's attorneys?
Well, I think people who've been watching these cases closely, if they're not lawyers, are probably scratching their heads at the legal system. They're seeing a system that seems to be falling down of its own weight in the sense that the arguments are delaying the cases over and over again. And even lawyers who've been watching, I think for the most part, are somewhat surprised at what has happened in many of these cases. Lots of these arguments that were made were real long-shot arguments. Even the presidential immunity argument, I think most expected that the Supreme Court might not take that case, or if they did, they certainly would not carve out the type of presidential immunity that they did. So I think this is a case that has really shocked the public and it's shocked the legal community. It's not gone the way that one would have expected. And it certainly is a huge win for the Trump defense team, because if the ultimate goal was to delay these cases, they have certainly succeeded in doing that. And it's now likely that the only case that will have gone to trial before the election is the case brought by the Manhattan DA. And now even that case, as you mentioned, is being held up for sentencing purposes because of the presidential immunity decision. I don't think it's likely that the judge in that case will throw that case out, or that he'll decide that the presidential immunity decision has any real bearing on that case. I think the defense will point to certain testimony in that case and argue that the presidential immunity case requires that case to be overturned. But I think ultimately the trial judge there will call that cumulative evidence or harmless error, and that case will stand. But in terms of all these federal cases, they are very much up in the air now, both legally and in terms of whether or not any of them will ever be tried before the election or will ever be tried at all.
Of course, because if Trump wins the election, the federal cases will sort of evaporate in one way or another. Thanks so much, Bob. That's Robert Mintz of McCarter and English. Coming up next, the landmark youth climate lawsuit reaches the end of the road. I'm June Grasso, and you're listening to Bloomberg. After nearly a decade, the landmark youth climate lawsuit is nearing its end, buckling under adverse court decisions and fierce opposition from 3 presidential administrations. It was back in 2015 that 21 young people took on the U.S. government with a novel argument that the government was violating their constitutional rights by allowing decades' worth of greenhouse gas emissions to spew into the atmosphere. The lead plaintiff in the lawsuit, Kelsey Juliana, 19 at the time, said the EPA had failed to implement a plan to reduce toxic air emissions as required by the 1990 amendments to the Clean Air Act.
They failed to act on creating that plan that would ensure the survivability and the thrivability of my generation and those to come. And so here we are 26 years later, asking for the most fundamental question: do you recognize me as someone who has rights, as someone who has the same rights to live and to live healthy?
But now, after 9 years of litigation and hopes that the case might finally make it to trial, the Biden administration was successful in having the case dismissed on a procedural point. My guest is environmental law expert Pat Parento, a professor at the Vermont Law and Graduate School. Pat, before we go into its tortured legal history, tell us about the novel claims in the Juliana case.
So this case was brought to try to establish a constitutional right under the federal U.S. Constitution, under Article 14, sort of fundamental right to a stable climate, or as Judge Aiken, who was the district court judge in Juliana, said, a climate system capable of supporting human life on Earth. Now, some of us might like to think there should be such a constitutional right, but the case was brought to try to establish that in federal court. That's had almost a decade run in the federal courts, which now seems to have come to an end.
And there were 2 different panels of the Ninth Circuit that heard this case.
Yeah, it does have a tortured procedural history.
It does.
So the original complaint really shot for the moon. It asked for a plan to reduce carbon emissions basically down to zero or net zero by a date certain, with milestones all along the way. Very, very aggressive demand that federal courts order the federal government, both the president and the Congress, order them to come up with a plan to achieve net zero carbon emissions for the U.S. economy. Very aggressive. That complaint went to the first panel of the Ninth Circuit, and by a 2-to-1 decision, that panel decided that kind of broad, comprehensive relief was not available under our jurisprudence. And so they dismissed the case on standing. They agreed that these youth plaintiffs had shown injury. Some of the injuries were physical. One of the kids had asthma, and we know climate change, by heating up the air we breathe, triggers asthma attacks. Another one of the youth plaintiffs said they were in a multi-generation ranching family and they were watching their ranch dry up. And so right down the list, the court said, yes, these individual young people have shown particularized injury, which is the first step in establishing standing. And this was a really important finding, the court agreed that the actions of the federal government, not just inaction, but the actions going back 5 administrations, Democrat and Republican, had been making the situation worse by continuing to promote and develop fossil fuels, et cetera. And so therefore, the plaintiffs had shown that their injuries were being caused or contributed to by the actions that the federal government was persisting in taking. So that was 2 steps towards proving standing. It was the third step that tripped them up, what we call redressability, which means assuming this injury, assuming the actions of the government are making the injury worse. What can the courts do about it? And that's where the first panel of the Ninth Circuit threw up their hands. They said, we simply don't have the authority under our constitutional system of government. That's a matter for the legislature and the executive branch to work out. The courts can't simply order it.
Then the trial judge allowed the youth plaintiffs to amend the complaint to only seek declaratory relief. Basically, tell us if we have a constitutional right to a safe climate or not. And it went back to the Ninth Circuit. The first panel was 3 judges appointed by President Obama. The second panel was a different story.
So now we're talking about 3 Trump appointees to the Ninth Circuit, and they excoriated Judge Aiken. They said it was basically arbitrary, almost outrageous, perhaps, for her to not read the original decision of the first panel as a requirement that the whole case be thrown out, lock, stock, and barrel. So that's what the second panel said, and that was a 3-0 decision. And then we come to the very last gasp, which is after this second panel throws the case out, the youth plaintiff lawyers asked for the full Ninth Circuit to review the case in what we call en banc. But it takes at least one judge of the Ninth Circuit to request a vote on whether to take the case up before an en banc panel, and they didn't even get one vote. So that's where we are today. The case has been dismissed. There's no further appeal to the Ninth Circuit. The only remaining avenue for appeal would be to file a petition for certiorari or review to the U.S. Supreme Court, something that terrifies a lot of us.
I mean, it's been at the Supreme Court twice already on other issues.
It went up twice on what's called a writ of mandamus, which is an extraordinary remedy. The Supreme Court never granted the petition for mandamus, but they, in 2 different orders, and particularly the last one written by Chief Justice Roberts, they made it crystal clear that this case should be dismissed. Roberts basically was speaking directly to Judge Aiken, and he was saying to her, you need to take another look at whether this case should be certified for review by the Ninth Circuit. And the Ninth Circuit should look very hard at whether a case of this magnitude and scope belongs in federal court. So, not too subtle message to the lower courts, get rid of it.
And I guess the Ninth Circuit got that message. As you say, the only legal path left for the plaintiffs is to appeal to the Supreme Court, a court that has not been friendly to environmental concerns. Is it wiser to just let the case end?
There's no way the Supreme Court is going to take this case for any other reason than to do further damage to cases being brought to try to seek remedies for climate. They could even revisit the Massachusetts versus EPA case, which turned on a 5-4 vote on whether there was standing to challenge EPA's failure to regulate greenhouse gas emissions. And the majority in that case are now gone, basically. So it's a totally different court. So the only reason this Supreme Court would take the case would be perhaps to review Massachusetts versus EPA and almost certainly issue a decision that would slam the courthouse doors shut once and for all on plaintiffs seeking remedies for climate change.
Every administration The Obama administration, the Trump administration, the Biden administration, some which we consider friendly to environmental causes, has been aggressive, so aggressive in preventing this case from going to trial. Why?
Yeah, I've said from the beginning, why not have the trial? My goodness, if they hadn't fought so hard all the way back to Obama, they could have had the trial over with. And Judge Aiken was not saying she was going to find in favor of the plaintiff. She was saying you take litigation one step at a time. The first question is their standing. The second question is there liability? And what she was saying is we'll have a trial and I'll make a decision based on the trial. So at a minimum, I thought, why not let them have a trial? You know, the Department of Justice is hired and paid for by us, the taxpayers, to defend the government in court. Courts are supposed to say what the law is, so do it. So, I mean, this all could have been avoided, in my view, if they just had the trial long before now. Either Judge Aiken would have ruled against the plaintiffs in one form or another, or the case could have gone up on appeal on the basis of a trial record, including all the evidence in support of what the youth plaintiffs were arguing and in support of what the government was doing to make the climate crisis worse. And wouldn't that have served some public purpose to have a record like that based on a trial tested by the evidence? I think the answer to that is yes, it would have benefited from that. Even if the end result was probably going to be no determination of a constitutional right. I think that's fair to say, even with the Supreme Court we had before the Trump appointees. But certainly now, there's no chance that this court would ever recognize such a constitutional right. Hell, they're busy revoking constitutional rights like Roe versus Wade. So we weren't going to get a favorable decision out of this Supreme Court no matter what. But at least having a trial for no less than at least historic purposes would have made the case what the dangers were.
So, Pat, is the Juliana case dead then?
I think it's dead. I think it's time to move on. Our Children's Trust are very reluctant to give up on it, but they've got other avenues. This isn't the end of the story on young plaintiffs asserting constitutional rights. I think it is the end of the road doing so in federal court.
And Our Children's Trust, which filed the Juliana case, has had more success with similar cases by young environmentalists suing in state court. One of those, Held v. Montana, was the first such case to go to trial, and they won.
That's right. And it's the first ruling, this by a lower court in Montana, Judge Seeley, issuing the first declaratory judgment. In that case, unlike Juliana, the court said, all I'm going to consider is a request for declaratory judgment. So this judge was smart enough to limit the case right from the get-go. But her ruling, backed up by 200 separate factual findings, the most detailed findings of fact we've ever seen in a climate case on science, on technology, on the physical and mental, emotional effects on these young people from climate change, particularly in Montana, and also challenging Montana's really, how can I put this delicately, arbitrary statute which prohibited state agencies from even considering the climate change effects of licensing, permitting fossil fuel development from pipelines, from coal mines, from coal-burning power plants, etc. So that's what the youth plaintiffs in the Held versus Montana case were arguing. Your energy policies are making the situation worse, and you have a law on the books that's blinding the agencies to the consequences of what they're doing, not only to Montana's environment, but to us as the future generation that has to live with all of this. So her decision was historic, and that was then taken up on appeal. The Montana Supreme Court has now heard oral arguments on appeal. We're waiting for a decision from the Montana Supreme Court.
And young people suing in Hawaii reached a settlement with the state to lower emissions, and that was a first.
So that's the first settlement agreement where a state has agreed to make changes not only to their transportation policies, but actually start ramping up significant investments where they can in mass transit on the Big Island and Oahu. Air travel is the biggest problem. So trying to figure out how are you going to deal with island hopping through airline travel is going to be a real challenge. But the point is, They reached an agreement. They've got at least an initial plan for how to begin to reduce emissions from the transportation sector, and then they'll go from there.
It's great to finally see these cases actually moving through the courts. Thanks so much, Pat. That's Professor Pat Parento of the Vermont Law and Graduate School. Coming up next, the conviction of Senator Bob Menendez. I'm June Grasso, and you're listening to Bloomberg.
This case has always been about shocking levels of corruption. Hundreds of thousands of dollars in bribes in the form of cash, gold bars, or Mercedes-Benz. This wasn't politics as usual. This was politics for profit. And now that a jury has convicted Bob Menendez, his years of selling his office to the highest bidder have finally come to an end.
Manhattan U.S. Attorney Damian Williams basically summed up the prosecution's sweeping corruption case against Senator Bob Menendez after the jury found the once powerful New Jersey Democrat guilty of bribery, extortion, and acting as a foreign agent of Egypt. Menendez continues to maintain his innocence and says he expects to succeed on appeal.
I have never violated my public oath. I have never been anything but a patriot of my country and for my country. I have never, ever been a foreign agent, and the decision rendered by the jury today would put at risk every member of the United States Senate in terms of what they think a foreign agent would be.
Joining me is Bloomberg legal reporter David Voriakis, who covered the trial. David, tell us about the prosecution's case.
The case centered around some explosive evidence that the FBI seized 2 years ago at his home in suburban New Jersey, and that was 13 gold bars, nearly $500,000 in cash, and a black Mercedes-Benz convertible that prosecutors said was the product of a bribe scheme that Menendez and his wife Nadine received over the previous 5 years.
The prosecution had a lot of different kinds of evidence against him. You mentioned the gold bars and the $500,000 in cash stashed around his house, an undercover FBI videotape, a witness who flipped and testified against him. What was the strongest evidence against him?
I think the strongest evidence would have to be the cash and the gold bars, both of which prosecutors presented in court so that the jurors could see what they're talking about. There was also 3 different summary charts that included thousands of lines of text, emails, calls, meetings. They had very meticulous and detailed chronologies because this was a subtle and discreet set of interlocking schemes that really could only be understood in their totality, in which jurors saw the timeline of a number of interactions and how they fit together. And so it took time to spell that out and for the picture to come into focus. And that picture, by the end of the trial, the prosecutor said was an overwhelming case against Menendez and the 2 businessmen tried with him, Will Hanna and Fred Davies.
And they were both convicted as well. And David, was there any evidence of a quid pro quo, of him saying, I'll do this for you in return for that?
I would say there was no specific admission, say, on tape or to another witness. Essentially, prosecutors built their case through inference, in which they showed that right after Menendez, say, met with the Attorney General of New Jersey on behalf of a businessman, he then called that businessman, who then texted someone else who said, I finally found peace. It's that sort of stringing together of a collection of different discrete pieces of evidence that lead to the clear inference that Menendez was engaged in bribery schemes with his wife, Nadine.
Menendez blamed his wife, and he had the benefit of being tried separately. She's going to be tried later. So Menendez wasn't put in the uncomfortable situation of pointing to his co-defendant and wife sitting at the defense table with him as the real culprit here. How much evidence was there against his wife?
There was a lot of evidence pointing to Nadine as a crucial go-between who connected Menendez with the businessmen who were on trial with him and with other people less directly involved in the case. She also set up meetings with Egyptian military people and intelligence officials, and according to the government, collected gold bars in cash from Fred Davies, one of the co-defendants, and also had a crucial connection and relationship with Will Hanna, who was the other co-defendant, and prosecutors said they were like brother and sister. They were very close, and some of the most damning evidence involved the Mercedes-Benz that another businessman, Jose Uribe, gave to her, essentially by handing her a $15,000 cash down payment in a diner parking lot in New Jersey, and then making monthly payments on the car for 2.5 years. There was also evidence that Will Hanna, the other defendant in this case, gave her a no-show job in which he paid her $10,000 a month for 3 months, and he paid off her mortgage on her home in New Jersey when she was in a great deal of financial distress.
You have to tell the story about the bell that prosecutors used to show that Menendez was the one in charge, not his wife.
There was a crucial meeting behind the Menendez house in September of 2019 at 10 o'clock at night, in which Jose Uribe, the cooperating businessman who pleaded guilty, said that he came over and spoke to Bob Menendez on the patio behind their house. And this was the night before Menendez was going to meet with the Attorney General of New Jersey and make the case that state prosecutors should drop their criminal investigation of someone who was close to Uribe. Jurors heard Uribe talk about Menendez summoning his wife Nadine with a bell, and that she came out from inside the house and delivered a piece of paper where Uribe wrote down the names of the people that he was interested in. The bell became sort of a symbol of whether Menendez really controlled Nadine or not, because the Menendez defense was that Nadine was engaging in a lot of corrupt acts behind Menendez's back. The prosecutors tried to puncture that defense and say that he knew everything that Nadine was doing, and that at certain times, as in the Bell incident, she was sort of under his thumb.
The prosecutor said the bell showed that Menendez was not a puppet having his strings pulled by someone he summoned with a bell. Now he's become the first member of Congress to be convicted of being a public official acting as a foreign agent. Was there any evidence that his actions compromised national security?
There was an incident in which Menendez, through his wife and then Will Hanna, passed along the number of people working at the U.S. Embassy in Cairo. Prosecutors said that was sensitive information at the time and could have compromised the people who worked there and exposed them to potential terrorist attacks. The defense said that that information had already been made public in a government report years earlier, but the prosecutors countered by saying that that was old information and the current information was not public. So while they didn't actually charge him with doing harm to U.S. security interests, they certainly suggested that that was a possibility by Menendez passing along how many people worked at the U.S. Embassy in Cairo.
After the verdict, Menendez said the decision would put every member of the Senate at risk in terms of what it means to be a foreign agent. Do you know what he meant by that?
Yes, their argument was during the trial that he was not engaged in being a foreign agent, that he didn't have Egypt's interests at heart, that in fact he only had the United States' interests at heart, and that as chairman of the Senate Foreign Relations Committee, he was engaged in diplomacy, not corruption, so that all of his interactions with Egyptian military and intelligence officials were acts of diplomacy and him exercising his power as chairman of that Foreign Relations Committee. So I think what he's saying is that if you find that what I did was corrupt and acting as an agent of a foreign country, then it's going to be the case for a bunch of other senators as well.
Menendez didn't take the stand, so how did he defend himself, particularly with regard to the gold bars and the cash and the Mercedes?
Well, the general defense strategy was to attack the witnesses through cross-examination, and his lawyers were quite effective at that. I'm sure they knew that he wasn't going to testify, so they put their case on primarily through the prosecution witnesses, although they did call a half dozen witnesses at the end. He had a number of defenses, but as you say, he had to come up with a story for the cash and the gold bars. As far as the cash went, he said that he had withdrawn cash in the amount of $400 regularly, say every 2 or 3 weeks for decades, and that would account for all the cash that was lying around his house. The gold bars, he said, were gifts to Nadine from her wealthy family in Lebanon, and the prosecutors countered that by saying that the larger gold bars that they seized bore the serial numbers that matched a list in the possession of Fred Davies, a prominent developer in Edgewater, New Jersey.
In 2017, Menendez was tried on unrelated federal bribery and corruption charges. That ended in a mistrial. Did the evidence here show that mistrial apparently didn't deter him? These schemes allegedly took place soon after?
Yes, that trial ended in the fall of 2017, and the evidence showed that the bribery plot in this case, for which he was convicted, began in early 2018. Of course, this was handled by the federal prosecutors in Manhattan, the Southern District of New York, presumably because they felt there would be a conflict for the prosecutors in New Jersey.
He is going to be sentenced on October 29th. He faces decades in prison on paper. What do you think a likely sentence might be?
On the most serious charges, he faces 20 years in prison. It's very rare in a white-collar case like this for a first-time nonviolent offender with a long career of public service to get anything like that kind of time. It's hard to know. If I had to guess, I would say maybe several years.
He is 70 years old, so the judge will most likely take that into account. Thanks so much, David, for your reporting throughout the trial. That's Bloomberg legal reporter David Voriakis. Menendez has 6 months remaining in his term, but Democrats have made it clear they don't want him in office any longer. Within minutes of the verdict on Tuesday, Senate Majority Leader Chuck Schumer called for his resignation. And New Jersey Governor Phil Murphy said the Senate should expel him if he refuses to step down. Menendez has taken a defiant stance since he was indicted in September of last year and hasn't indicated whether he'll voluntarily resign. But expulsion requires a 2/3 majority and is exceedingly rare. The last time it was even considered by the Senate was almost 30 years ago. And in our history, only 15 senators have ever been expelled, almost all of them during the Civil War. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.